So once again, welcome to our webinar. Participant phone lines are on mute. We do have a Q&A and a chat option if you are interested in asking our panelists any questions. Today we are discussing the recent developments in trade secrets and employee mobility in the workforce. And our presenters today are David Clark, William Cook, and Aime Dempsey. Without further ado, I'll turn it over to the presenters. Thank you again for your patience, and welcome to the webinar.
Good morning, everybody. This is David Clark. Thanks, Sylvia. As you said, I'm joined by my colleagues Aime Dempsey and Will Cook. We're all resident in Epstein Becker Green's New York office and work in the firm's litigation and labor and employment practices. Today, we're going to take a look back at what we saw in the space of trade secrets and employee mobility in 2017 and early 2018. We'll discuss recent headlining cases and strive to provide insights into the latest developments and expected trends in this evolving legal landscape. So next slide, please. Here are the topics we're planning to cover today. First, we'll look at what legislatures have been up to in terms of potential and actual new laws regarding non-compete agreements, which is a hot topic around the country. Second, Aime will discuss some significant new non-compete cases. Third, I'll talk a bit about the increasingly common use of garden leave clauses in lieu of non-competes. Fourth, Aime will review recent cases in the world of trade secrets. And for our fifth and sixth topics, Will is going to review the practical impact of the Defend Trade Secrets Act of 2016, including some practice points and case developments involving that influential statute. Finally, Aime will close out the program with a segment on changes in regulatory and statutory restrictions on confidentiality agreements. So let's jump right in. In the last year or so, several states have enacted or considered enacting new statutes to regulate and limit the use of non-competition agreements for low-wage earners, or to abolish the use of them almost entirely. Several of these bills seek to impose risks of liability on employers who require employees to sign non-competition agreements with overreaching or unenforceable terms. Similar federal legislation has also been introduced to reform the perceived misuse of non-compete agreements. Next slide, thanks. For example, effective in June 2017, Nevada enacted a statute which provides that non-compete agreements are unenforceable unless they are supported by valuable consideration, which is not defined in the statute, do not impose any restraint that is greater than required for the employer's protection. Third, do not impose any undue hardship on the employee, and lastly, impose restrictions that are appropriate relative to consideration provided. Also, the statute requires judges to blue pencil overbroad non-competes to render them enforceable. And finally, in connection with reductions in force, or reorganizations or restructurings, non-competes are only enforceable while the employer is paying the employee's salary, benefits, or the equivalent. Next slide, thanks. In Washington State, lawmakers last year introduced a bill in which would have required employers to disclose the terms of a non-compete agreement in writing to the prospective employee no later than the time of the acceptance of the offer of employment. Or if the agreement is entered into after the commencement of employment, the employer must provide independent consideration for the agreement. Additionally, this bill, HB 1967, would allow an employer to recover actual damages, would allow an employee to recover actual damages, statutory damages of $5,000, and attorney fees and costs if an employer required that employee to sign a non-compete agreement that contains provisions that the employer knows are unenforceable. So that Washington bill was introduced February of last year, was reintroduced January of this year, and is now in committee. So that has a chance of passing. Next slide. Turning to the Midwest, in 2017, the governor of Illinois, in proposed legislation, suggested that any contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind, other than non-compete agreements signed by employees earning $1 million or more per year, and non-competes signed in conjunction with the sale of a business, should be unenforceable. This law would have invalidated many thousands of non-compete agreements that currently bind workers in Illinois, and would move Illinois sharply in the direction of a state like California, in which non-compete provisions in employment agreements are pretty much unenforceable. Some have speculated that this proposed sea change in Illinois law was an attempt to catch the eye of Amazon as it decides where to place its second headquarters. And it was indeed surely intended to make the state more enticing to startups and tech companies. But this proposed law has not been enacted in Illinois yet. Next slide, please. Continuing to move eastward, more efforts have been made with regard to proposed legislation banning non-competes for low-wage workers. In Maryland, a bill proposed last year would have voided non-competes with employees who earn less than $15 an hour or $31,200 per year. A New York Senate bill, if enacted, would have banned non-competes if an employee's wages are under a salary threshold of $40,560 per year. And also a measure was introduced in New York City to ban non-competes for low-wage workers in New York City, where in that bill the threshold was $13 per hour for city employers with 11 or more employees, and $12 per hour with employers with fewer employees than that. These bills have not yet been enacted into law, but you can see by their number and scope which way the political winds are blowing. Those winds are being felt at the federal level too. Two federal bills were introduced, but have not yet been enacted into law in the past year or so. Like many federal bills these days, their titles are interesting acronyms. First is the Ladder Act, which stands for Limiting the Ability to Demand Detrimental Employment Restrictions. This bill would, one, prohibit employers from entering into non-compete agreements with low-wage employees engaged in commerce or the production of goods for commerce, and two, require an employer of such employees to post notice of that prohibition in a conspicuous place on the employer's premises. The latter act defines low-wage employee as an employee who earns less than the greater of $15 per hour or the state or local minimum wage. Also, in order for an employer to require an employee who is not a low-wage employee to enter into a non-compete covenant, the employer would have to disclose the requirement for entering into the covenant before hiring the employee. The latter act would also direct the Secretary of Labor to enforce a complaint of a violation of the act in the same manner as a complaint of a violation of the Fair Labor Standards Act, and impose a civil fine on any employer that violates the latter act. The other federal act introduced last year on this topic was the MOVE Act, which stands for Mobility and Opportunity for Vulnerable Employees. The MOVE Act really provides the same terms as the latter act, except that it defines low-wage employee as one who earns less than $15 an hour, the state or local minimum wage, or $31,200 per year. Finally, I'll end this segment with a few words on Massachusetts, where a minority of dedicated legislators have pushed for years, so far unsuccessfully, to limit employers' use of restrictive covenants. In the last year or so, 6 separate bills have been introduced in Massachusetts, 3 of which would require employers to include a garden leave clause or other mutually agreed upon consideration in the non-compete agreements. The garden leave clause would require employers to pay former employees on a pro rata basis either 50% or 100% of their earnings for the duration of the restricted period. None of these bills have passed yet, and Massachusetts especially has a track record of introducing bills intended to limit the use of non-competes, which fail to become law. But in any event, employers across all states, especially in these states I've just discussed, should stay tuned. If employers are seeking to have certain employees sign non-competes, they should continue to draft them in narrowly tailored and enforceable form, or face the consequences. So now I'll hand things off to Amy Dempsey.
Thank you, David. In the last year or so, we have had several cases around the country that continue to interpret the very factual intense statutes and common law on restrictive covenants. Next slide. Going first to Florida, the Supreme Court of Florida recently consolidated two cases to address an interpretation of its statute on restrictive covenants. The statute, section 542.335, defines a legitimate business interest. And under Florida law, a legitimate business interest is necessary for any contract that has restrictions on competition to be enforceable. Statute 542.335 lists 5 legitimate business interests: trade secrets, valuable confidential business or professional information that is not trade secrets, substantial relationships with prospective or existing customers, customer, patient, or client goodwill, which is further defined, and an extraordinary or specialized training. The cases and issue before the Supreme Court that were decided in last September had to do not with any of those enumerated legitimate business interests, but the restrictive covenants were non-competes in the healthcare field. The employees in question were marketing representatives for healthcare companies, or HHCs. Those HHCs provide skilled nursing and other services to homebound patients. But the way that they find those patients is through referrals from doctors, their social workers, other referral sources. They don't have some kind of way of finding the patients otherwise, so they argued that the restrictive covenants, in each case 1 year, fairly limited geographic scope. One was 2 counties, the other one was 50 miles. They argued that those restrictive covenants should be enforceable even though the referral sources were not an enumerated legitimate business interest. The court first analyzed whether the 5 legitimate business interests listed in the statute were exclusive and decided that they were non-exhaustive. It was a non-exhaustive list, so that what is required going forward is a fact and industry-specific inquiry. And then in this case, they decided that the referral sources are protectable depending on, or may be protectable depending on the context and proof adduced at trial, but in these cases, they were protectable because the HHCs successfully argued that they were the lifeblood, that they were really the substitute for a client interest, that these marketing representatives developed these referral sources, and when they moved on to another HHC, it was a legitimate business interest for the former employer to have some lead time that made the non-compete legitimate. In contrast, in Massachusetts, that relies on common law still, having not passed the statute, as you just heard, a janitor moving from one company to another was found not to have violated an enforceable non-compete because the remembered information about the identities and needs of his clients was not a protectable legitimate business interest. Next slide. moving to New York, and Judge Rakoff, last summer, he issued a decision on whether certain activities taken by a group of employees who moved from one document technology and gathering company to another violated any non-compete lines. They left as a group of 4, and the former employer brought litigation against the 4 and the new company, L Discovery. By the time it got to trial, the other motions had reduced the claims to a tortious interference, or that was the main issue. Marketing them as a package deal was not found to be against their non-compete. It was not a breach of contract, or for them to have developed some spreadsheets and things in their one-year non-compete period because they didn't use those spreadsheets. They were just getting ready to compete, and that is permissible. And importantly, it was not tortious interference for the new employer to have provided the employees with some bonus money for the period of time that they were not competing, and with indemnification for the litigation that was brought against them, because the indemnification clause was not to be effective if the employees were to have found to violate their obligations to their old employer. So the court analyzed and decided that the indemnification provision as written was not something that could be said to induce the employees to violate their obligations with their former employer, because it would have been rendered ineffective had those violations been found. Instead, it was just a normal type or acceptable type of inducement for them to be hired by the new employer, so that they would be protected from the lawsuit that was in fact brought against them, even as long as they were found in the end not to have violated their obligations. In Indiana, the law disfavors non-competes in general, but is more likely to allow them in the sale of a business, as most jurisdictions are. Here, a couple of things were at issue. A seller had 2 businesses. He wanted to retire and sell both of them. He sold one first that was in the business of manufacturing and distributing fuel additives. When he sold that one, he entered into a 5-year non-compete with the new company. Then when he sold the second business, which was in the business of manufacturing lubricant materials, he gave some assistance to that second business at the time, for a period of time. When he sold the second business, which was called Petroleum Solutions, it had a relationship with the first business, known as ET Solutions, as a distributor for some of the fuel additives in some markets. It was not a competitor of the ET Solutions, but ET sued and argued that the assistance that the seller, Elder, gave to the Petroleum Solutions violated his very broad 5-year non-compete because it fell under the assisting indirectly prohibition. So in turn, Elder argued that the 5-year non-compete was unenforceable given Indiana's disfavor of non-compete agreements. The court found that a 5-year non-compete in the context of the sale of a business was enforceable, and it was enforceable over the geographic scope of North America as written, because even though when he sold it, ET Solutions was not in business throughout North America, the buyer successfully argued that he had a legitimate and successful plan to expand the business, and therefore the broad non-compete was necessary to protect the goodwill throughout North America. However, the court decided on summary judgment that the elder did not violate the non-compete because the assistance that he gave to Petroleum Solutions when it was a distributor for ET was not assisting indirectly. The court said that really you have to look to the meaning of the non-compete, which is to protect against unfair competition, not just any broad assistance, even if it potentially falls within the language of the non-compete. Also, Elder was assisted by the fact that as soon as Petroleum expanded its business and started to compete with ET, he advised Petroleum he could no longer help them and immediately stopped assisting them. However, at that point, he did not void a lease on favorable terms that he had provided to Petroleum, and the court found that that also did not violate the non-compete. It was not indirect assistance to allow the favorable lease to continue. In fact, reading the non-compete that broadly would lead to an absurd result. So the court was very focused on the exact language and the exact facts of that situation. Then in the Third Circuit recently, they addressed a situation under Pennsylvania law where both the plaintiff and the defendant were in IT services, and they both were working with the same company, Time Warner Cable. First, the plaintiff, Aime, was working with Time Warner on a special project. At some point, for some reason, Time Warner decided that it would solicit the defendant, Infosys, to take over that project. In the process of that transition, Infosys invited a particular employee of Aime to apply for a job, and a couple of independent contractors it also wanted to hire. When it went through the process of looking to hire those employees, it asked them if they were subject to any non-compete or other restrictive covenants, and they all said no. It turned out that they were subject to non-competes, and Aime sued for tortious interference and argued that the circumstances of the situation meant that Infosys really knew or should have known that these non-competes were in place, even though the employees had advised for whatever reason that they did not have non-compete agreements. The court found that that direct knowledge, or there was no evidence of direct knowledge on the part of Infosys, and that circumstantial knowledge or circumstantial evidence of knowledge is not sufficient to support a claim for tortious interference, which under Pennsylvania law requires knowledge of the contracted issue. Circumstantial evidence or speculation that, well, it's common in the industry to have non-compete agreements, so really Infosys should have figured it out, is just not sufficient. They did what they were supposed to do by investigating, asking the question, and when they were advised that there was nothing they had to worry about, they could not be successfully sued for tortious interference. Next slide. Next. Oh.
Next slide, please.
I'll go on to talk a little bit about XFactor company versus Elder. Thank you. That one was the 8th Circuit interpreting Iowa law. There, the individual was a sales rep for 5 years for XFactor, which sold fertilizer. After 5 years, in about 2005, he decided to not be an employee anymore, to go into business by himself, but become a sales representative, or what they called an area manager for XFactor. And he sold their product exclusively, but as an independent contractor. He bought the product and sold it at a markup, and but he had a 3-year non-compete agreement. The issue is whether the non-compete was enforceable. The court said no after looking at the specific facts of his relationship with XFactor. He handled the product as he saw fit. He had to buy it from XFactor, and he had to pay for it within 10 to 14 days, so that if a customer didn't pay him, he was the one who suffered the loss. He stored it at his own warehouse, but also XFactor pointed out that he stored some of it at a railroad tank facility provided by them, but he also paid for that facility. So, you know, it was his relationship. The customers were relationships developed by him, so that when he decided after a period of time that he wanted to sell a different product, they had bought XFactor's product because of him, not the other way around. They didn't buy from him because of the relationship with XFactor. You know, he received about $1,500 a year if he sold from XFactor, if he sold more than $1 million worth of product, so he did get some money from them, but the court decided that, you know, in connection with its overall dislike of non-compete agreements, that it was not enforceable for this independent contractor under the circumstances. Going back to Illinois, which David discussed a bit, an employee went to another employer and was abiding by his non-compete agreement, but did send some LinkedIn messages to some of the individuals at his old employer and his former employer, who ultimately saw sort of an application for the new employer on his LinkedIn page and applied and went to the new employer. The question for the Illinois Court of Appeals was whether this was a recruiting effort to recruit former coworkers in violation of his non-solicit, and the court decided it was not. Looking carefully again at the actual facts of this case and what the activity was, the court found that his basic activity was just to essentially send LinkedIn invitations to these people. He didn't, you know, even though it brought them to his page where there was some other information about his new employer, he didn't seek to solicit them to go to the new employer by simply sending LinkedIn invitations. The court contrasted that with other situations in other cases where using LinkedIn, the solicitation was much more direct. So again, it's definitely a very factual inquiry in each case. Staying in the Midwest and going to Wisconsin, another state with a statute. The question was whether the statute, which prohibits covenants not to compete, applied to non-solicitation of employees. And if it does apply to non-solicitation of employees in addition to non-competition, does it cause those provisions to be unenforceable? The Wisconsin Supreme Court decided yes, the statute section 103.465 does apply to non-solicitation of employees, and it can at least render such provisions unenforceable. What you look at is whether the employee and new employer are restricted from competing fully in the market. And here, the court maybe went a little out of its way, this was earlier this year, to find that the non-solicitation provision at issue, while it didn't restrict the movement of the employee himself, it restricted the choice for the new employer and for the employee in the labor pool by excluding employees from the former employer. So just excluding the hiring of those employees in the eyes of the Wisconsin Supreme Court restricted the labor pool enough to render the non-solicit provision unenforceable. Therefore, the statute shouldn't be interpreted broadly, and you should look at exactly what the effect what the effect is in terms of restraint of competition, not what the words of the restrictive covenant are, just. So more generally, courts still struggle with choice of law and forum selection clauses. And Nebraska court granted a forum selection clause and a transfer motion. In Massachusetts, they found that the choice of law and forum selection clause of Massachusetts for a California employee violated California public policy. And, additional cases raise issues like you can't enforce your non-compete if you don't adhere to the contract yourself. So in Space Age Consulting versus VizCon, the employer violated the wage and hour laws, and therefore the agreement was not agreement for the non-compete was not enforceable. In Mid-America Business Systems versus Sanderson, the plaintiff couldn't get a TRO because the agreement was signed after the beginning of employment and lacked adequate consideration. It should be said that many states allow continued employment as sufficient consideration for non-compete. Georgia continues to work on its blue pencil limits and what the courts can do to edit non-competes to be enforceable. I will now turn it over to David to discuss the garden leave issue in the context of non-competes.
Okay, thanks, Amy. We've referred to garden leave once or twice already today, so let's start by backing up a little. What is garden leave? Garden leave clauses are contractual provisions which typically require that an employee give notice of some period, say 30, 60, or 90 days, of his or her intended termination of employment. For that prescribed notice period, the employee remains an employee and may not work for any competitor. The employer, at its discretion, can have the employee continue working, including to assist in the transition of duties to another employee, or the employer can modify the employee's duties, including by reducing them substantially or even completely. The employer has no obligation to assign work to the employee and may even exclude the employee from the company's premises. And that's the source of the term, as an employee can be told to go home for the period before termination takes effect. So he or she is left to tend to his or her garden during that time period and is not free to commence new employment. The employer is, however, required to continue to pay the employee and oftentimes to provide benefits during the garden leave period. The garden leave clause thus performs several functions, including ensuring that a key employee is available for an orderly transition, ensuring that a business line is adequately staffed until a replacement can be found, and in some cases providing an opportunity for an employer to negotiate to try to persuade a resigning employee not to leave. In addition, the continuation of the employment relationship during the garden leave means the employee still owes duties of loyalty to the employer during that time, and it operates as a de facto non-competition and non-solicitation restrictive covenant, prohibiting the employee from competitive activities like soliciting customers. It also meets the public policy considerations of enabling an employee to earn a living while he or she is being so restricted from leaving. Further, any post-termination non-competition or non-solicitation restrictive covenants would begin to run from the date on which the garden leave period expired, not from when the employee first announced his or her decision to resign. Garden leave provisions may be included in all sorts of agreements between employers and employees, such as offer letters, employment agreements, and stock option plans. The practice of employers using garden leave clauses is common in the banking and financial services industry, in Britain, Australia, and New Zealand, and it's increasingly common in such fields in the United States. Next slide, please. One important reason that garden leave clauses are becoming more popular as an alternative to traditional non-compete is that they're more likely to be enforced than, say, a one-year post-employment non-compete contract. Garden leaves typically are shorter in duration, as I said, 30 to 90 days usually, and are seen as less punitive because the employee is still being paid. So generally, they face less hostility when they're challenged in court. But it should be noted that case law on garden leave clauses is less extensive than for other kinds of restrictive covenants so far. Just before I get to this slide, I'll say a few words about compensation because that can be a thorny issue with garden leave clauses. When drafting a garden leave clause, an employer will need to determine what kind and how much compensation to provide during the garden leave period. Oftentimes, during that period, the employee will continue to receive his or her regular base salary and benefits, but will cease eligibility for bonuses or other incentive pay. If this is the case, the employee who receives the lion's share of his or her pay through bonuses may claim that he or she is not receiving adequate consideration and that such garden leave should not be enforced. Even more complicated situations arise for purely commissioned employees. Because if such a person is home tending the garden for 3 months, he or she is not earning any commissions for that time period and not getting paid. In those circumstances, employers may want to set a formula to pay compensation to the employees during the leave, but they must be mindful as well to comply with the applicable commission agreement and not to run afoul of any applicable wage and hour laws. Employers can also choose to limit or decrease certain fringe benefits during the garden leave, including, but not limited to, accrual of paid time off. Such a modification of benefits during the leave will likely have a negligible impact on the potential enforceability of the garden leave provision. So moving on to the next slide. Pros and cons. Garden leave clauses are a useful tool that employees potentially can use to protect their confidential information and customer relationships for a bit of time after a key employee resigns. Although legal precedent is not extensive, as I said, they're more readily enforced by courts than traditional restrictive covenants. They allow for more protection to the employer, as well as orderly transitions of client and work responsibilities. And if drafted appropriately, they can afford flexibility to the employer. The cons include higher costs to the employer. You're paying the person potentially to do very little. Garden leave periods are usually shorter than non-compete periods, so an employer could face competition sooner from an ex-employee who only has a garden leave and has served out that time as compared to an ex-employee with a longer non-compete. And these clauses can present logistical headaches if the employee is told to go home, but then the employer changes its mind and calls the person back in to help with something during the leave period. If they've already been cut off from their emails and stuff, you have to set that up again. I certainly see the pros as outweighing the cons when it comes to the use of garden leave provisions, and I think we'll see more and more companies using them in the future. Now I'll turn it back over to Amy.
Thank you, David. We talked about some restrictive covenant cases. Courts continue also to analyze what constitutes a trade secret. Usually when a defendant is accused of theft of trade secrets, they go to court trying to narrow the definition of trade secrets to say whatever they may have taken does not constitute a trade secret. In the Sentinel Insurance Company versus Yorktown Industries case in the Northern District of Illinois last year, however, you could argue that the defendant tried to expand the definition of trade secrets. The situation was that Yorktown Industries had a policy with Sentinel Insurance Company covering personal and advertising injury. That is, that if they were found to have taken or copying in its advertisement or on its website another person's or organization's advertising idea or style of advertisement, they were covered under the insurance policy for that liability. They were sued in California for trade secret theft and turned to the policy and argued that Sentinel had an obligation to defend and to cover them under the advertising injury policy, arguing that trade secrets counted as stealing someone's advertising idea. The court first decided that it was ripe for summary judgment because looking at whether a particular contractual provision is covered by an insurance policy is for the court to decide, and then compared carefully the underlying complaint in the California action to the insurance policy and found that the trade secret theft allegations did not at all fall within the advertising injury policy, and in fact were excluded by an exclusion provision in the definition of advertising. So first, it didn't fall within the definition of advertising, and second, it did fall within an exclusion for trade secrets. One of the big reasons it looked at that it wasn't a trade secret was that it wasn't used to advertise to a bunch of customers or on the website the allegedly stolen trade secrets, but that they were set aside to take sort of customers one by one. It was not an advertising tax at all. It was a theft of trade secrets, and Sentinel did not have an obligation to defend or to cover the complaint. I'm going to turn it over to Will, who's going to talk a few minutes about the Defend Trade Secrets Act.
Thank you, Amy. The Federal Defend Trade Secrets Act, DTSA, and also referred to as DTSA, was signed by former President Obama with an effective date of May 11, 2016. Thus, we are coming up on its 2-year anniversary. DTSA received extensive bipartisan support leading up to its enactment, passing in the House by a vote of 410-2 and passing unanimously in the Senate. Through this legislation, trade secret protection has been placed in the sphere of federal question jurisdiction, similar to patents, trademarks, and copyrights. The legislation codified at 18 U.S.C. Section 1836 created a federal private civil cause of action for trade secret misappropriation, in which an owner of a trade secret that is misappropriated may bring a civil action if the trade secret is related to a product or service used in or intended for use in interstate or foreign commerce. And of course, that's quite easy to show in today's interconnected world. The size of the employer and the dollar value of the trade secrets are irrelevant under DTSA. Before the enactment of DTSA, without diversity jurisdiction or an independent federal cause of action, for example, a cause of action under the Federal Computer Fraud and Abuse Act, companies seeking remedies for trade secret misappropriation had to sue in state court, where laws protecting against trade secret misappropriation tend to differ from state to state. For instance, the definition of trade secret differs from state to state, and different remedies may be available for trade secret misappropriation in the variety of states. DTSA provides a uniform statute to be applied nationwide in federal court. DTSA is largely based on the Uniform Trade Secrets Act, UTSA, and arguably 48 of the 50 states have adopted the UTSA. So DTSA doesn't change those 48 states' substantive laws, but now employers have the opportunity to get into federal court to assert a federal private right of action for misappropriation of trade secrets, which they can and often do bring together with a state law misappropriation claim arising out of the same facts over which the federal court can exercise supplemental jurisdiction. Importantly, DTSA does not preempt or displace any state law causes of action for misappropriation, including state law UTSA claims. The definition of a trade secret in DTSA is defined generally as all forms and types of financial, business, scientific, technical, economic, or engineering information if the owner has taken reasonable measures to keep such information secret and the information derives independent economic value, actual or potential, from not being generally known to another person. I'll address the definition of misappropriation shortly in order to focus on the practical impact of the legislation on this slide. In the 22 months since DTSA's enactment, courts have given practitioners some guidance over the scope of DTSA and how employers can take full advantage of DTSA. The only two states that have not adopted the UTSA are New York and Massachusetts, although there was a bill pending in Massachusetts to adopt the UTSA. That's Massachusetts House Bill 43. It was introduced on January 23rd, 2017 in the 190th General Court, and we understand that bill has some traction compared to some of the others that have failed in the last several years in Massachusetts. Thus, in New York and Massachusetts, DTSA gives employers some important advantages they wouldn't otherwise have. One, they can get into federal court on a claim for misappropriation of trade secrets. Two, employers who bring a DTSA claim can get attorney's fees if they are successful in prosecuting a DTSA claim. Three, DTSA expands New York as well as Massachusetts substantive law somewhat because those two states require trade secrets to be in a continual use to be able to bring a claim for misappropriation of those trade secrets under their common law. DTSA doesn't have that requirement and also does not contain any balancing test to determine if something is a trade secret as in New York. And four, employers can seek an ex parte seizure order of the trade secrets in question if the employer shows extraordinary circumstances, which I'll discuss a bit later. Before we move on to the next slide, however, another practical impact of DTSA is if an employer wants all the benefits provided under the statute, for example, an award of attorney's fees and punitive damages, the employer must ensure that their employment agreements contain a notice provision that provides employees who are whistleblowers with immunity if those employees disclose trade secrets when allegedly reporting violations of the law. However, the statute lacks a penalty for violations of the notice of immunity requirement. So if an employer fails to include such a notice provision, that does not mean the employer cannot bring a claim under DITSA. The only consequences are that the employer will not be entitled to attorney's fees or punitive damages, which are two important remedies otherwise available under DITSA. In any event, the employer has an incentive to modify its employment agreements accordingly. We can move on to the next slide. In response to motions to dismiss under Federal Rule of Civil Procedure 12b-6, the courts have closely scrutinized DITSA claims to ensure they adequately allege all the elements of a DITSA claim. For example, misappropriation under DITSA is defined as A, the acquisition of a trade secret of another person who knows or has reason to know that the trade secret was acquired by improper means, or B, disclosure or use of a trade secret of another without express or implied consent. Thus, under the well-known Twombly-Iqbal standard, and that is the general federal pleading standard applicable to motions to dismiss, DITSA plaintiffs must adequately allege, among other things, improper acquisition and or improper disclosure or use of a trade secret, and they must do so through more than conclusory allegations or labels. Therefore, in the Prominence Advisors v. Dalton case, a case from the Northern District of Illinois, in December 2017, the court dismissed the DITSA claim because, first, the defendant, the former employee of plaintiff, properly acquired the trade secrets as they were provided to him in his role as plaintiff's director of technology, so there was no improper acquisition. And second, plaintiff did not include any facts to support the allegation that defendant disclosed the alleged confidential information without authorization or consent. As explained by the court, plaintiff did not allege to whom defendant disclosed the confidential information, when he did so, or any other information that, if true, would tend to show that the defendant used or disclosed the information at all, since his departure from employment with plaintiff. It should also be noted that even though the court in Prominence Advisors dismissed the DITSA claim on the ground that it did not allege improper disclosure, the court found that the complaint had adequately alleged a trade secret. It stated a complaint need only identify the alleged trade secret in a general sense. For example, an allegation generally referencing business models, business plans, and product development plans is sufficient under DITSA. The next slide, please. An additional requirement when pleading a DITSA claim is that a DITSA plaintiff must adequately allege that it took reasonable steps to maintain the secrecy of protected information. Two relatively recent cases show the importance of pleading how the confidentiality of the alleged trade secret was maintained. In Raven Tire versus McFarland, a case from the Western District of Kentucky, in February 2017, the court dismissed the alleged trade secret violation with prejudice because the plaintiff failed to allege any steps that it took to protect the alleged trade secrets from disclosure. As explained by the court, the complaint was entirely devoid of any allegations of how plaintiff protected the information in question from dissemination. For example, there was no suggestion that the defendants were restricted from sharing that information due to a non-disclosure agreement. However, in Greco versus Barreto, a case from the North Dakota Federal District Court, in March 2017, the court ruled that the plaintiff satisfied its pleading obligation by alleging that it required employees to enter into a confidentiality agreement and an acknowledgement of plaintiff's information technology end user policy, and that they did not permit the information to be removed from the workplace. It should also be pointed out that it was undisputed that defendant had downloaded information from Plaintiff Agreco's computer system onto his own personal computer in direct violation of the plaintiff's clear policies. The takeaway here is that an employer should have protection in place to maintain the confidentiality of its trade secrets. For example, proprietary and confidential information is password protected, and there are limitations on who can access that information. and that is alleged in the complaint as clearly and as detailed as possible in order to satisfy this important pleading requirement under DITSA. Next slide, please. One part of DITSA that was fairly controversial prior to its enactment is the civil seizure mechanism. For a plaintiff employer, instead of just seeking a TRO under Federal Rule of Civil Procedure 65 and then having the court set the matter down for a preliminary injunction hearing, the civil seizure mechanism is a tool that can be used in which a court on an ex parte application by a trade secret owner may issue an order providing for the seizure by a U.S. Marshal of property necessary to prevent the dissemination of the trade secret that is the subject of the action. Following issuance of a seizure order, however, the court is required to hold a seizure hearing where the party who obtained the seizure order has the burden to prove the facts underlying the order. Civil seizure may be ordered only in extraordinary circumstances and requires the showing, among other things, that an order pursuant to Rule 65 or another form of equitable relief would be inadequate, and or the applicant has not publicized the requested seizure. The case law to date shows that courts routinely reject these, perhaps out of concern that these ex parte seizure orders could lead to abuse by overzealous plaintiffs. The case law also shows that the courts instead analyze whether the plaintiff is entitled to some form of injunctive relief under 65. For example, in 000 Brunswick Rail Management versus Sultanoff, a case from the Northern District of California, in January 2017, the court denied a request for a seizure order because the court ordered defendant to deliver the devices at issue to the court at the hearing scheduled 2 weeks later, and also ordered that the devices not be accessed or modified in the interim. The court there just didn't see the need for such extraordinary relief. And in Magnesita Refractories versus Mishra, a case from the Northern District of Indiana, also in January 2017, the court did not enter a seizure order under DITSA, which the application requested that a certain laptop be seized so that it could be imaged. There the court found that an order issued pursuant to Rule 65 could be used instead to accomplish this. It appears from the decision that the defendant was still employed by Magnesita and the laptop was apparently accessible and was seized pursuant to an order entered pursuant to Rule 65 and not DITSA. You should know, however, that the first successful ex parte seizure order under DITSA was granted by a New York Federal District Court. In Mission Capital Advisors versus Ramaka, in July 2016, in an unpublished order, Judge Lewis Stanton in the Southern District granted an ex parte seizure order after the defendant appeared to have evaded personal service of a previous temporary restraining order. The court found that this conduct on the part of the defendant was sufficient to satisfy the first and the most difficult prong of an 8-factor test for an ex parte seizure order under DITSA, and that is that the order issued pursuant to Rule 65 of the Federal Rules of Civil Procedure would be inadequate because the defendant would evade, avoid, or otherwise not comply with such an order, and that's why the primary reason that such the seizure order was entered. Employers should be reluctant to seek these. They're very, as the case law shows, they're extremely difficult to obtain, and we still have our remedies under Rule 65 to seek TROs and preliminary injunction hearings. Next slide, please. Timing. So also, defendants may have a timing defense when the alleged misappropriation occurred before DITSA's enactment, which was, again, May 11th, 2016, or there is no indication in the pleading as to when the alleged misappropriation occurred. Of course, this will become less relevant as time goes by, particularly given that we are almost 2 years out from DITSA's enactment. Courts have generally held that DITSA applies to misappropriations that began prior to DITSA's enactment if the misappropriation continues to occur after the enactment date, and that's because DITSA defines misappropriation also as the disclosure or use of a trade secret. DITSA, unlike the UTCA does not preclude an application to continuing misappropriations that continue to occur after the enactment date. Therefore, for example, if a defendant left his job before DITSA was enacted but remained in possession of alleged trade secrets after DITSA's enactment, it is likely a court would find a viable claim under DITSA. But I'd like to direct your attention to Cave Consulting Group versus Truven Health, where in April 2017, the Northern District of California stated, without facts about when post-enactment use occurred and whether the information disclosed was new or somehow different from the prior misappropriation, plaintiff has failed to state a claim under DITSA. And in Brand Energy and Infrastructure versus IREX Contracting Group, in March 2017, the Eastern District of Pennsylvania held the plaintiff could pursue a DITSA claim because the amended complaint alleged multiple uses of trade secrets that occurred after DITSA was enacted. The parties were competitors in the construction industry, and even though some of the trade secrets were obtained by plaintiff's former high-level executives, the defendants, as early as 2014, the defendant continued to use those trade secrets after the enactment of DITSA. The takeaway from these two cases is be sure to allege that the misappropriation occurred after May 11th, 2016, or if you can't allege that the defendant made use of the misappropriated trade secrets and that occurred after DITSA was enacted, and explain how defendant used those trade secrets in other than conclusory language. At this point, Amy will conclude the webinar with a brief discussion of regulatory and statutory restrictions on confidentiality agreements. Thank you.
Thank you, Will. Thank you, everybody. I know it's a little bit after 12 and we got started a couple minutes late, but I just wanted to say a few words about what you want to watch out for when you enter a confidentiality agreement. A lot of times cases settle between employers and employees or former employees, and sometimes those settlement agreements have confidentiality provisions. There are also other contexts when employees agree to not reveal confidential information. But as employers, you want to be careful about how those agreements are phrased, because several agencies have or claim to have the right to review such agreements, and they may find the agreements violative of applicable regulations under certain circumstances. And recently, some of these agencies may be taking a little bit more, a continuingly more aggressive approach to examining these confidentiality agreements. They tend to have about three, sort of broadly, three concerns. These agencies want to make sure that even if there are confidentiality provisions in settlement or other agreements, that an employee can still whistleblow if they see something wrong. For example, OSHA states its purpose as to assure safe and healthful working conditions for working men and women. Therefore, it will review agreements and will not approve those that it sees as having a gag provision prohibiting or restricting or even discouraging employees from protected activity, including filing a complaint with the government agency, participating in an investigation, testifying in proceedings, providing information to governments. And usually they find these problems, in their view, in confidentiality or potentially non-disparagement provisions of settlement or other agreements. So OSHA, will claim the right to come in and look at agreements, and if they find that there are provisions that, in its view, will discourage employees from whistleblowing, they may, say that those have to be changed. Similarly, the NLRB, the EEOC, FINRA, and the SEC will look at agreements, and they're also concerned that employees can proceed with their protectable right to engage in discussions of the workplace and workplace conditions, including sharing of compensation information. The NLRB and the EEOC will frown on provisions that don't allow compensation information to be shared. There's also the required DITSA notice of immunity disclosure. So the takeaway from all of this is if you're entering agreements with your employees or former employees, whether they're settlement agreements or elsewise, restricting what they can discuss and protecting employers' legitimate interest in keeping its confidential information confidential, you want to review those agreements carefully so that they don't discourage whistleblowing, that they allow reporting to any of these agencies listed and potentially other agencies, and that they don't restrict the employees more than necessary to protect confidential information. Please, be sure to let us know if you have any questions about any of these materials that we packed into this hour, and I thank you very much for your attention.
Thank you to our presenters, and thank you for joining us today during this webinar. In approximately 2 to 3 business days, we will be following up with the availability of the webinar recording as well as access to the PowerPoint materials. As you can see, our presenters' contact information is on the screen, and we will also follow up with their information in an email. But if you have any questions, please direct them to the presenters directly. And thank you once again for joining us. Have a great day.